Hmm. Oh, I did date that house here. All right, welcome back. We are on Thursdays, our last substantive class, studying Landlord-Tenant relationship part 2. And on Tuesday, we'll be going over an old exam. I'm not sure which one yet. I'll let you know on Thursday. I haven't decided yet. And that's about it. After Tuesday, unless you come by at office hours, I don't see you again. It should be sad, but we're almost there. Something's up. My projector is not working. It didn't work this morning either, so I have to figure this out later. I'm not exactly sure what's going on. So no screen, but I don't really need it today. Questions, things on your mind? No? All right, let's do a poll question. I forgot to give it this morning. I'm actually mad at myself because all the problem with the screen. You'll see it on your app, so you can't see it. You'll no. those days, isn't it? Screen, is it there yet? Everyone just pull up class 26. I'm sorry. I have something that Zoom isn't working either. YouTube is working, so I have no idea what's going on. Okay, so do you have a question there, Alyssa?
Yeah, thank you.
Okay, so I'll read it as well, so just to be a little more. It's a alliance is interest in black and is judgment proof. L
And then he would have to sue.
the sublease. With a sublease, could the land?
He's still responsible if I suppose.
Very good, thank you. She's correct. And the distinction between a sublease and an assignment, they're different. Assignment, you're handing over all of your rights. The tenant's no longer the hook for anything. It was called the sub-assignees on the hook. But with a sublease, there's still liability. So the landlord can go out for any rent. Okay.
That phone goal that going to hold on to the liability, even though there's no benefit to it necessarily.
I think the only major is who's liable for damages. This is the next. So I think it's liability broadly. That makes sense. Okay. And there was actually an Airbnb party. It was in Pittsburgh. People were basically renting Airbnbs. What were you looking at there? What's that?
I'll check out loud.
Oh, okay. Well, it's not funny. But the was that Kevin? Okay, well that's too late now. All right, the question's over. All right, you can answer false to me. That's fine. The issue with the Airbnb is actually perhaps a little tricky in some places. In New York, it was largely designed to help hotels, but apparently in other places there's a trend where people basically are renting Airbnbs, having massive house parties, and leaving someone else with bill, which is somewhat different. And I think that can be handled with some means short of banning it altogether, maybe requiring bigger deposits or something else. I was just in New York this weekend, so I'm very bitter against New York. I hate going there. I love coming back to Texas. I'm so happy I can land. It's like, freedom. I can really breathe free once again. Okay. All right. I spoke at Brooklyn Law School yesterday, and I showed them my classic Texas cardboard vaccine card. Like, this is not real. I'm like, no, this is real. This is what we have. They're like, where's your app? Like, we don't have an app. So, it's like, I got this little stupid card. That's what I have. That's what we have. The guy didn't want to let me in the building, but eventually they let me in. Okay. Where am I? Yes. So we're talking today about landlord-tenant law. In today's class, we'll be discussing what happens when the tenant breaches and the landlord behaves badly. In class on Thursday, we'll be talking about what happens when the tenant does everything correct, but the landlord breaches. Right. So today is, and on Thursday, the landlord breaching. Right. What you'll find in both the cases for Thursday is a movement away from the common law rule, these strict common law rules, and a movement towards modern, equitable practices. We are all in New Jersey now. We can't escape New Jersey, as it were. Okay. The first case involves what's called a default of a lease. Hanny, you're next. What does it mean to default? Also, if you have a mortgage and you fail to make your payments on the mortgage, you are defaulting on the mortgage. So you'll see this also in credit law as well. But the default is the word that's being used. All right. This first case, I got to admit, is one of my favorite cases in the book. The facts are just so good. It's like Spider-Man stuff, right? I love this case. Pierre, you wanna give us the facts? We start us off with the facts in Berg v. Wiley from Minnesota.
So this case is from the Minnesota Supreme Court in 1978. It was started in 1970 where Berg initially that lease was with Philip, and there were also some conditions on that lease. The conditions were first.
So you start one at a time. So what was the first condition?
Yeah. So the first condition was that the tenant agreed to bear all costs for repairs and remodeling.
Okay. So Pierre, the fact that this provision was in the lease suggests what?
Well, so that means that everything, any cost, is going to have, it's going to be responsibility of biller.
Did the landlord anticipate that repairs would be done by putting this lease in the by putting this provision in the lease?
Probably not anticipated, but I think it was like saving his back.
Okay. Well, I think the guy wanted to open up a pool hall, and generally, when you open up a restaurant of any kind, you have to make renovations. So they understood any cost would be incurred by the tenant. All right, Deborah, what's the second major lease, major term that was in the lease?
That he could only make changes in the building structure, but he could make changes in the building structure, but it had to have prior written authorization.
Good. And so, what is the significance of this? See that? I didn't even see it. I turned my head 1 second. You guys are good. What's the significance of requiring written consent or written authorization to make repairs?
I think it's kind of to like the first one, like Pierre said, that he was kind of trying to like save his back in case that happened. So just like an oral, like yeah, don't worry about it, or an oral waiver, or like whatever it might have been, like wouldn't have counted. So it had to be written and authorized.
That's right. That's right. Okay, good. Again, this is similar to the assignment provision. You needed written consent. And in theory, at least, the landlord could withhold it, saying, you know what? You want to build a new, I don't know, new oven or something for your kitchen. I don't want you to build it. Because think about it. If there's only a 5-year lease and substantial work is done, it may be harder to relet the apartment in a couple of years, right? Every substantial change that's made to sort of the structure of the property impacts the ability to relet the apartment. All right. The third one, Andres, is I'm sorry, Matt. Oh, you do the name flips confuse me. Matt, the third one is perhaps most significant, right? What was the third clause?
That the tenant would operate a restaurant in a lawful and prudent manner.
Lawful and prudent. So these are two different factors. Let's start with lawful. I'll go to prudent in a moment. What does it mean, Maddie, to operate a business in a lawful manner?
Follow the laws.
Oh, isn't that so easy, right? And how do you know if a business is following the laws?
And you probably can look at like the local ordinances. Like in this case, they had health violations. You see based on what the requirements are if they violate.
So let me just say, so you're a first-year law student, very bright student. Can you just read the health code and know what the law actually says? No. All right, so Andres, let me ask you a follow-up question. Who gets to decide what the law is? The court. And how does a case get to the court? Or in the case of an inspector, what happens?
Oh, would mean like an inspector.
Yeah. Health inspector comes and sees rats crawling around. Looks like Bruno's house, right? What's he going to We were watching Live Encanto on the plane trip this weekend. My goodness, yeah. That's something that keeps him sane. Okay, go on. Yeah.
I was just saying, I mean, they're probably going to give you like a warning and say,
Good. Right. So I assume you've never had health inspectors in your home or your businesses. Maybe you have, but here's the way it usually works, right? The inspector shows up, either announced or perhaps surprise visit. He sees violations of code. He'll usually give you what's called a warning and say, okay, you need to fix X, Y, and Z. You're nodding.
yeah, I had a business owner. Yeah,
Oh yeah. You tell us. You worked in business. Yeah, tell us.
so I have a bar, and you got surprisingly the fire marshal and the health inspector, consecutive days,
Oh man.
and you have no idea they're coming over. They go through everything. You have to show them everything, and then they just start checking off things on a board, and they give you a warning after warning. But they can. Fire marshal was able to shut us down and fix these things we weren't allowed to open to the public.
Oh, they.
Consecutively after the other.
And how much time did they give you to fix the error, to fix the issues?
The fire marshal shut us down immediately.
Oh,
but
boy.
we had to fix it before we could open up again.
For the next day, yeah.
I forgot what the thing was, because we threw that away because there was no point, because fire marshal came the next day.
Did you ever actually do the things that health inspector said,
We could.
and you shut down?
Yeah, we had no choice.
Yeah. Oh, you just taught my class. Thank you. Very good. No, I mean that's exactly right. And I'll ask you in a couple minutes. When she put the clothes remodeling in the window, what was she doing?
Oh,
Was she ever coming back?
No.
No. Of course not. Right. All right. But yeah, thanks for that, Kevin. We appreciate the insights. Right. So the way it usually works is the inspector come by and he says, you have to fix X, Y, and Z. And if you don't fix it by a certain date, we'll issue a fine or citation, or even we'll give you an order to shut down the business. Now, it's rare that they shut you down immediately. It must have been a really bad restaurant. How bad are we talking about, my friend?
oh, mine?
Yeah.
Great.
Oh yeah. That's great.
That we, with the fire marshal, we had a fire hazard because we sold alcohol and hookah
Oh man.
in proximity of each
Oh,
other.
that sounds like a bad idea.
Right. My family,
Oh boy.
electrical system. So,
Remind me not to visit this place. Yeah. It's closed, so it's good. All right. Thanks for that, Kevin. I appreciate it. All right. So going back to Andres's point, they give you notice, right? In theory, at least, to X, Y, and Z by a certain date. But realistically, unless something minor, you're not going to be able to fix it, right? They're saying, okay, we're going to shut you down in a week, but at least give you some notice. But let's say in theory there's a conflict, right? Let's say that Victoria, right? Victoria, let's say that there's a dispute over what the code means, right? Maybe the inspector says you need to have, this width, but you say, no, I'm under a different provision, it has to be a wholly this width. And let's say they issue a fine. What do you do if you issue a fine and you disagree with the code? Dispute in court, right? And let's say the trial court judge rules against you in favor of the health code and health inspector. What happens then? You appeal it, right, Victoria? And then the appellate court rules against you, right? And then what do, Victoria? To the state Supreme Court, right? Eventually you get to a final judgment, right? At that point, is it clear whether you're acting lawfully or unlawfully?
Depends on the decision.
Let's say the state Supreme Court says, Victoria, you're dead wrong. You got nothing. Do we have a clear final judgment? Okay, so if you appeal the case all the way up from the I should say lowly, but the health inspector, if you appeal the case up from the health inspector to the yeah. Okay. But until you get to the point, Victoria, do you know? No. So I'll come back to Zamali, right? How do you know then what it is to be law?
You never really know until
You don't know until what?
you don't really know until you do what those were.
Yeah. Is that realistic, Molly? That a landlord has to wait for you to appeal a case all the way up to the state Supreme Court, maybe 2 years to get an appeal? So then, how do you know what lawful means? Do what who says?
The landlord usually buys.
So the landlord gets to decide what lawful means.
It's usually no.
All right. So here's the problem, right? Everyone is self-interested. We all are, right? We are rationally self-interested human beings. We always admit it. We always will read the law in the benefits of our interest, unless you're a judge. Well, there's nothing wrong with that. That's how the law works, right? A landlord is not neutral. A landlord will read the law to benefit his side, which means you get allowed, right? So we have this clause tray, this lawful clause. How the heck are we supposed to enforce this? In this case, in general, how can a landlord ever objectively enforce this lawful clause?
I guess he asserts his right, whatever he thinks that right would be, and then, similar to what Victoria was talking about. If you don't agree with it, then you, I guess, can challenge it.
But you're already evicted, right? None of the core rules on whether your code thing is backed out. You don't live there anymore. You don't work there anymore.
So what is the landlord trying to accomplish right now?
He wants to get them out. How can the landlord be trusted to enforce this lawful clause?
I guess really can't, because he's the one that made it up. So there's not really a lot to hold him accountable. He's the one making the rules.
Okay, so I think this. Thank you. I think this row more or less got what I wanted to get across to you, right? So I got 4 or 5 people. That's good. The idea of what's lawful is not self-evident, right? at some point, some neutral fact finder or judge or someone else will have to decide. A landlord using self-help, he's making a judgment by himself that something is legal. He's like, oh, this is illegal. I'm going to go change on your locks. Right? One of the costs of self-help is you have landlords make decisions by themselves. And this can come up in a much more mundane scenario. Let's say landlord says, oh, you missed your rent payment by 1 day. I'm going to your locks. And it actually turns out that the mail got, delayed by a day, right? Just the mailman forgot to deliver it. He delivers a check the next day. A simple, misunderstanding could be resolved very quickly. Or let's say that, the lease said that at a point in time, the rent increases. And the landlord misread the lease. It was supposed to go into effect in 1 day. He said it goes into effect earlier. A judge could say, no, the landlord was not owed this greater rent at this point. But if you start with the point of self-help, you're not able to adjudicate these issues neutrally. Okay. Questions so far. All right. The next point is this word prudent. Daniel. So so far we spent, a few minutes talking about lawful means. What does prudent mean?
I think that's the, probably actually means that one.
Okay. The word prudent might bring you back to torts. The reasonably prudent person, bad memories, right? Just awful flashbacks, negligence, I think. This is even more subjective, I think, than lawful, because at least with lawful, there's a statute, there's a code, there's something you can go by. Zach, if you're a landlord and you have this prudent clause, can you say that any business action is imprudent? I mean, is there really a limit there? What you can say is imprudent?
Yes, but I'm not really sure who's supposed to impose that limit. Like, I think reasonableness as a standard is kind of what prudent means, but
Yeah.
just say what's reasonable.
So can I evict at will with this prudent standard? Is there some like limitation on it?
Like you said, at that point, it would be evicted, so.
All right. This clause, if we take it seriously, would give the landlord absolute power, right, to evict on just about any reason. If you couple this clause with a self-help standard, you can change a lock for just about anything. So you might guess it's not going to be the rule here. So then we get to the fourth criteria. Garrett, what's the fourth criteria in this lease?
Like
The fourth term. Yeah, the fourth term.
was if
Okay. Why? I'm sorry, what does it mean to prevent them from retaking the premise?
to have the option to retake.
Yes.
It ensures that the landlord, I guess it solidifies the landlord's right to repossess.
But what does it actually mean to retake possession? Just literally, what does that mean?
Having a hard time without using retake.
No, there's a very easy, the facts of this case tell you the answer. What does it mean to retake the premise?
Evict the tenant,
What do you actually do?
take the
How do you take it back?
By evicting them.
No, stop it. What are the facts of this case? What does he actually do? What happens here? What's the cause of the conflict?
I mean, there was a breach.
Caitlin, what do? How do you retake the premise? What do you do to keep the other person out? Change the locks. Was that so hard? That's how you do it. I suppose maybe none of you have ever been evicted, right? But if you get evicted, they change the locks on you and you can't get in anymore, right? That's how you do it, right? When you say retake the premises, you change the locks on the person. And by the way, you can sell their stuff. Don't laugh. A common law, if a person owed debt, if a tenant owed debt and you evicted them, you got to keep whatever was inside. And you would sell their stuff to pay off whatever debts they had. People were nodding. Some stuff works. Maybe maybe just you never exposed to this, but in this case, that's actually what happened. Okay. Everyone with me so far. All right, so Caitlin, I'll come back to you. What happened after Wiley signed the lease with Phil Berg? Okay, that's fine. And then what happened? What does it mean to assign the lease to a sister? Okay. Did the brother retain any interest in Blackacre and any interest in the property? Was he liable for any unpaid rent or any damage or anything else? Okay, he was completely out of the picture, right? Now, one more question for you, Caitlin. When all the terms that were present, she took over all the terms that were present. Clause number 3 regarding various lawful manner operation, and clause number 4. I'm sorry. What did I say? Oh, bless you. I'm sorry. I heard question. I heard voice. That's okay. Well, bless you. So when the sister took over the lease with the assignment, she accepted all the clauses, including number 3, which concerns operating a lawful manner, and number 4, which was the right of the landlord to retake the premise, which means changing the damn locks on her. All right. So Kathleen operated this business for about a year, and then a conflict arose, right? What happened, Janati? Did she get any permission from the boss, from the landlord? No, she did not. And then what happened? Okay. So this is not like Kevin's restaurant where they shut down the place, or the hookah bar, they shut down the place right away. But the health inspector comes by and he says, you're operating an unclean kitchen. And they gave Kathleen a list of things that complete in a couple weeks. Right? At that point, the attorney for the landlord wrote to Kathleen and said, you are in breach of your lease. Right? Joel, what provision of the lease did you, but the health code said you can fix it in X, Y, and Z, right? Do this. Why did the lawyer for the landlord say there was a breach or default?
It was lawful.
Correct. But had it been settled that she violated the law?
No.
Didn't the inspector say if you fix it by a certain date, you're not in violation of the law? In other words, if she fixed everything by the date that was given, would there be any fine or arrest or anything imposed? No. Right. That's the idea of the health code. You're given a warning and say you must fix this by X, Y, and Z. If you do X, Y, and Z, you're in compliance with the law. So at the time the lawyer wrote this letter, Joel, had she actually violated the law yet? Right. So the lawyer basically took it to himself to decide what it means to be lawful. I think that's what we have here. And the lawyer said, make these changes by a certain date, and if you don't, the landlord will retake possession, which means changing of the locks. Angela, did she make any of the changes? She did not. All right, so Angela, now we get to the weird part. My favorite case in the book. I love the facts here, right? So Angela, we get to this this final day, July 13th. What happens? What goes down? Skulking? Oh, that's a good word. I like that word. Skulking. That's a good word. What exactly? Well, even bit more than skulking. What did he do? It's kind of weird. Yeah, he did Spider-Man, right? And I don't know if he was hanging like this, upside down like a sloth. I'm not exactly sure what he was doing, right? But the way the book describes it is basically, so on that Friday, she dismissed her employees. That means she fired everyone, right, Kevin? Job that day? Yeah, yeah, yeah. They all got fired, right? She closed the restaurant and she put a sign in the window saying closed remodeling. Angela, what did that sign mean? Closed remodeling? Was that a lie? Probably. Kevin, was that a lie? Yeah, yeah. Okay, that was good. I like that contrast. That's good. Yeah, she's lying. Maybe she was. I don't know. According to Kathleen, she shut the shop down for about a month to come up to health code. Health code didn't give her that much time, weeks. So at that point, she actually was in violation of the law. Was it by July 13th when she didn't make the changes? She had to basically shut down the restaurant. Okay. Then comes the landlord, right? He enters the restaurant to change the locks, and Kathleen said, "I'm not going anywhere." So then he left. He didn't change the locks. And later that evening, around 9:30, Kathleen was sitting in the restaurant with her friends, and she observes Wiley hanging from the awning, peering, skulking, if you will, into the window. Wiley opened the back door and demanded entry into the restaurant. Wiley says he observed Kathleen removing paneling from a wall. Does anyone want to guess why? They might be removing paneling from the wall. Someone had this idea earlier. I didn't think of it, but it's actually a good idea. Anyone? Why would you? Yeah, Arturo? Oh, you think she was trying to fix the health violations? That's not what the landlord thought. Andres? Yeah, that's what someone else said earlier. I sat right there, in fact. Yeah. Someone earlier said, everyone people nodding, she was trying to steal the copper wire, which apparently is valuable. I didn't know this is a thing. I heard this on the news that people are stealing like copper wiring from air conditioning, causing like hundreds of thousands of dollars in damage for like $50 in copper. Yeah, Arturo?
Yeah, people actually try to steal copper wire.
They zap? Oh well. Sorry, that was mean. That was. I'm sorry. That was mean. That was mean. I'm sorry. Okay. I'm bad. Well, I know that theft is in the right of catalytic converters. I didn't know what a catalytic converter was. I still don't know what it is. But people have seen what? I don't know. I don't know cars. That's a flux capacitor. Anyway, so the landlord may have accused the tenants of stealing copper wire. We don't know from the facts. I don't. Maybe they were trying to root out cockroaches. Fine. All right. So what happens next? Kathleen calls the cops. Burr calls the sheriff. Okay. Kathleen calls the cops. Burr calls the sheriff. I don't know why they had maybe relations with the law enforcement. And then what am I up to next? Trey, so what do the police do when the sheriff and the police get there? Okay. Could the police have actually rejected Kathleen at that point? Whoa. Oh, what a very crafty answer. They don't like to. What do you mean they don't like to? Unless they have what? Oh no, that probable cause for search a criminal. Why do the police not want to cause an ejectment here?
Because they don't have.
Again, what's
they
the
don't have
ground?
police
What?
in front of them to see
Why
them.
is the landlord trying to evict the tenant? What's the allegation? Okay, are the police situated to determine if there's a breach of a contract? What do they need to do the ejection? Not a warrant, but court order. Yeah, warrant's criminal. Different story. Okay, that's right. Criminal. I'm sorry. A court order. The police will want a court order. It's not the police officer's job to decide. It's not the police officer's job to decide, are you in breach of a lease? That's a legal question with due process and other rights that attach to it. So the cops will not do a thing. I think your cops were actually being reasonable, right? I think the cops here were being actually reasonable. Okay. They said just maintain the status quo, talk to your lawyer, and figure this out on Monday. All right, Colin. So they'll agree, okay, we'll keep the status quo. We're not doing anything now. Then what does do? What does the lawyer tell him? Go change your locks, right? Right. Now, Colin, let me ask you a question. Was this unreasonable advice from the attorney?
He believed that the vendor stealing stuff, and he would probably go back and steal stuff again.
Okay. Was this good advice or bad advice? We'll get to that point later. So they come in a couple days later. They change the locks. Kathleen shows up. He doesn't work. And at that time, there were 16 months left on the lease. And then, like 2 weeks later, Wiley signs to the new tenant. So, using a Spider-Man shtick, he had another person in mind for the unit, right? He's like, look, I don't want this health code violation here. Let me get someone else in here. Okay, Natalie, what happens next? Right. He sued Wiley for wrongful eviction. Why was the eviction wrongful, Natalie? So that's the issue, right? Had she in fact violated the breach? I'm sorry, had she in fact violated the term? That is, had she breached, was the usage unlawful? All right. Now, the court never actually decides that question. I actually want to know. Like, I'm actually interested in that question. They don't decide that question, right? Or at least the Supreme Court of the state, right? Instead, there's another issue, right? Brissa, what was the issue the court actually has to decide? Correct. What the court actually ends up deciding is, was the landlord's self-help permissible? Because you notice they actually award damages for the wrongful eviction by $3,000 for the wrongful eviction, right? The lost profits, whatever, that's the profits from the business that could have been made. But there are actually damages also for the wrongful eviction. Okay. Morgan, what was the common law rule regarding self-help repossession? Okay, very good. With the common law rule, okay, with the common law rule, self-help was permissible. But Morgan, how must this help be done? What's that word that has to be done? What's that adjective or actually adverb? It must be done blank. Peacefully or peaceably. Yeah, exactly right. Thank you. You could not use force to remove it. So if you were to go in, pick up a person, throw them on the curb, yeah, that's a battery. Good job. Right? Even at common law, the most common law state jurisdiction you have, in forceful removal. It has to be peaceful. Right? Victoria, what does it mean to peacefully remove someone? What's the only way to peacefully remove a person? I mean, can you peacefully evict someone? Is that even possible? No, they don't agree. That'd be too easy, right? That's too easy. What does it mean to peacefully evict someone or peacefully remove someone? Well, what about what happened in this case where you changed the locks when she wasn't home? Is that peaceful?
They support that.
Why not? But I mean,
Like, after the night before what happened, he knew that he was starting an issue by changing the law.
okay, all right, very good. Thank you so much for that. It's not clear if it's even possible to peacefully evict a person, right? I suppose the least confrontational approach would be to change the locks, right? It would be to change the locks when she's not home. And the court said something like, the only reason there wasn't blows was because she wasn't home when they changed the locks up. But if that's the case, isn't self-help always going to be legal? Right? So I'm not sure the court's actually right about this. I think the court's being a little bit soft, right? I think at common law, changing the locks, what Garrett and Caitlin would ask before, that was the way you did self-help, right? It wasn't you throw them out the door, you just change the locks, or you put a padlock on the door, which is even easier, right? And you have to, of course, lock the windows, all these other things, people try and get in. Okay. But as is the trend in all these cases, the court does not adhere to the common law rule. Molly, why does the court abandon the common law rule of self-help? Whatever, they don't even have to decide what peaceful means. Why do they abandon this common law rule here?
they decided that the owner of land shouldn't be the judge of his own right.
Oh, that's a good answer. Yeah. The court says that the landlord should not be the judge of his own rights. We have this term saying what's lawful, it should be up to a neutral judge to decide it. The landlord cannot take the law into his own hands because doing so risks violence, risks chaos, when it's not even clear who is at fault. I'm sorry, that name, I'm sorry. Samantha, instead of the self-help, what should the landlord have done? Right, and what's that process called? Good, what's summary proceedings?
Basically, it's intended to be a quick and efficient way to recover possession after terminating the tenancy.
Good. The court says that self-help is not necessary. It's not permitted, but it's also not necessary because there's a legal process the state created. At common law, ejection was a very lengthy process. It took a lot of work to eject someone. That's why self-help was an attractive alternative. But in the modern era, every state has enacted what's called summary eviction or summary proceedings, where you can get someone out in a matter of a few weeks. Right? So instead of changing the locks on her, he could have just gone to court and had her evicted right away. Now, there's a risk, though. What if she had gone to court and said, I'm not in breach. I plan to fix these issues, and I will fix them. Give me another month. I don't know that a justice would, or justice of the peace would evict in that case. I might say give her another month to think about it, to make the recommendations. So I think what happened here, and this is just my theory, which is based on speculation, he had a tenant who wanted to move in. He didn't want to deal with going to the courts and lawyers and all this stuff. It's cheaper, just hire a locksmith, right? I mean, what's cheaper, going to the courts or hiring a locksmith? Hire a locksmith, put in a locksmith. But by going to the a lock changing, he basically litigated for almost 2 years in the state Supreme Court. I mean, that's not cheap. So I mean, maybe his attempt to save a few, no, more. 1978, this case stretched for 8 years. I didn't ever realize till now. The case began in 70 and finished in 78. So almost 7 or 8 years went on before this was over, which is actually a lot of time. But the court says we are abandoning the common law rule. There's a summary procedure that should be used instead. At the time, no judge had decided if Kathleen in fact breached. Therefore, the landlord had to pay damages. Going forward, the only lawful means to dispossess a tenant from leased property is through summary proceedings. And so today the modern rule is the majority rule in not every state, but most states as well. Self-help is very much frowned upon for landlords and tenants. You just don't use it anymore. You risk a forceful removal action, which you don't want to do. Okay. Yes, Nick. Auction. You sell it, we trash it. I mean, it's valuable. Well, again, at common law, if they owed you damages, you could actually use their stuff to satisfy their debts. And if there's any leftover amounts, you would give it back to the client, to the tenant. But usually, or not usually, but perhaps in many cases, the amount owed was greater than the value of the stuff. I mean, especially if it's restaurant health code violations, it probably wasn't in the best shape. I mean, I'm just guessing. Yeah, good. Arturo?
What did you say that she breached the notice for violating health code?
Well, look, she arguably breached when she made changes without getting his permission. That was arguably a breach. And that's probably a much easier one. I don't know if getting the notice was itself a breach. There's probably case law in the state deciding what that term lawful means. I don't know the answer. My guess is the mere notice of the breach, the mere notice of the health code violations might not be sufficient. It would have to be an order from a health inspector saying, okay, I gave you notice, you didn't make the changes, I'm going to issue a citation or a fine of X dollars. I'm going to shut you down. I think that would have been a better time to have done the eviction. He moved like a couple of days early. If he just waited a couple of days and the health inspector shut her down, this would have been a much easier case for him. Like he did a Spider-Man routine a little bit early. All right. Yes, Clark.
Would it have been, I don't know, easier or easier on the landlord if he had relied on the prudent part more so than the lawful?
I think so, and I made this point earlier with I think Zach and Daniel. But the problem is, I bet there's case law in the state saying prudent can't mean whatever you want it to mean. There's got to be some sense of it, or maybe the term's not enforceable because it's so subjective. So again, there were probably a couple ways when she could have identified a breach. Had he gone to court, he would have had her out in a couple weeks, but instead he litigated for like 7 or 8 years. So again, I think and the next case also proves this point. If you're a landlord and you pick a fight with someone who's very litigious, it goes on forever and you may lose in the end. All right. Questions on Berg? And again, this is the rule in Texas, and I think just most states. You can't use self-help for evictions. Use the courts. Louisiana does allow self-help. That much I know. I researched this last year during the Mississippi. It's either one of the Fifth Circuit states, Louisiana or Mississippi. There's an eviction moratorium. Yes, Nick.
What happens if you do so?
In which state? It's a tort, right? You can't. Right. I mean, the Texas Supreme Court, I'm like 90% sure on this, said we no longer allow self-help in Texas evictions. I'm like 90% sure on this one. I looked up this up maybe last year, but I'm not positive. I mean, it's a battery. It's forceful eviction. You can liable for damages. I mean, you want to do it, good for you, right? But you're on the hook for damages. 1 and 2. Well, here's the thing. Merely because you throw the person to the curb doesn't mean they're evicted. So they're still entitled to the apartment until a judge says otherwise. So you eventually have to go through the summary proceeding, and then you get hit with damages for a suit afterwards. Pierre?
So in the modern rule, can you actually look for a preliminary injunction, for example, just like to get them out as quickly as possible?
2 or 3 weeks is pretty quick. You're not going to kick them out overnight, unless you're a fire marshal, right, Kevin? Then you shut down the door right away.
They can shut down the door, but they can't keep,
Right.
they're different.
Oh, that's true. Okay, fair point. I didn't think about that. Yeah. So your staff can stay in, but you can't have customers coming. Is that the rule?
There's a weird law in Florida as well that we utilize all the time, where if you block the door in the area that we were in, the commercial real estate now became a private real estate. You can do whatever you wanted on the inside of the building. But once somebody left the premises, they couldn't be allowed back in.
I've never heard that rule, but okay. Okay. So basically, last call is last call.
Well, yeah, last call is that call. When you lock the door,
Sure. I have no idea, but I'll take your word for it. All right. Anyone else? Let me walk through the rules for summary proceedings here in Texas, which are going to be, I think, pretty indicative of how they work in other states. The purpose of summary eviction is to make the process very fast, right? In Texas, from start to finish, about 3 weeks. All right, which you may say, wow, that's way too slow. And oh, wow, that's way too fast, depending where you're coming from. But it's about 3 weeks. This is all pre-COVID. There are backlogs like you can't even imagine because of COVID in everything. So these are the pre-COVID numbers. I can't vouch what it is now. The first step is notice, right? Before you take any legal action, you must give the tenant 3 days notice that you intend to vacate. And that 3-day notice period is designed to, alleviate any misunderstandings. Like, maybe the check got lost in the mail. Maybe the check bounced because you had a transfer error. I mean, there are a lot of small things like, oh, I'm so sorry. Here, let me give you the money, right? In other words, if it can be cleared up in a couple days, eviction will be a disaster, right? Don't evict if it can be cleared up in a couple days. All right, then you must actually serve the citation. This is something usually the sheriff does or the constable, which says you are required to appear at a hearing before this justice of the peace on such and such date. And you must give at least 6 days notice. So usually about a week beforehand, you have to provide notice that there's a hearing on this date before this court. Very often, the tenant will request an extension and a second extension and a 15th extension, etc. And with COVID, there are extensions that's the wazoo. But in theory, at least, if he shows up at his hearing, the hearing itself is not very long. It might take a few minutes. There's no requirement to have counsel present. Usually the landlord will have counsel. The tenant might not. Most tenants who are getting evicted don't have the funds to pay for an attorney. We have a upstairs on the 10th floor an eviction clinic. If this is a law that interests you, consider volunteering on the eviction clinic. It's the school does a lot of meaningful work there. Anyway, yes, Angela.
So that's 6 days after service
Well, you give 3 days notice, right? And after 3 days, you can then give notice of the hearing. So at least you have 3 days and about 6 or 7 days till the hearing. So far about day number 10. Okay.
Yeah.
All right. So then the justice issues a ruling from the bench. There's not going to be a written opinion. This is not like a reported case. It's like, hey, you didn't pay your rent, eviction, proceed. The tenant has a 5 days to appeal. What's called the county court at law. That's what the court is. The court's called the county court at law. Okay. At that point, assuming the appellate court rejects it or just rules against them, eventually the constable comes in. This is like the sheriff. And the constable must put a 24-hour vacate notice on the door. And this is literally, I don't know if you've ever seen this, it's a sign put right in the door saying you must vacate in 24 hours. And if you don't, the constable comes in, he will, if necessary, break the lock, open the door, and remove you forcibly. I mean, that at that point, the constable has an order in his hand from a judge, so it's not like he's just making stuff up. He has a judicial order. So if everything moves expeditiously from start to finish, it'll be 3 weeks. It's not usually this quick. Like people request extensions and they need more time. Arturo, you shaking your head? Why are you laughing?
I mean, it's hard, but like I've noticed that during COVID, like I was easy to go into that route, off the beforehand, and things like that. But if there are bars and doors and windows, somebody just come out with a chain off the gate to the door and put a new lock on it. So then that way you get in, you have to break chain breaker, but that's just to get inside and want to get your stuff out before they came in to take all your stuff.
Yeah. 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 I mean, usually the landlords win. It's rare they lose. But I suppose if the landlord wins, he can appeal. Yeah. So they both have appellate rights. But in theory, at least, a minimum of 3 weeks. This can be more in most cases. Texas is fast by other standards. The book has pre-COVID numbers, and I'll give you the post-COVID in a minute. Pre-COVID numbers. In DC, it can be 3 or 4 months. In New York, you require 30 days notice and 3 to 6 months to evict. Massachusetts, up to 2 years. That's not even accurate. I saw an article in the New York Times just this past weekend. Never read the New York Times. All bad stuff in there. No kidding. Right. Tenant has been there for almost 5 or 6 years, and he's requested a number of extensions, and with COVID and everything else, and he's not leaving. And there are just all these ways to extend it, so the dates can go on indefinitely. I had an uncle who passed away, but he lived in New York. He was elderly, and he had a woman living with him as a live-in aide. And when he died, she didn't move out of the house. She just stayed there. She had no right to be there. She just wouldn't leave, and all of her stuff was there. And my uncle said, "Okay, Josh, you're a property professor." He's like, "So can I just change the locks?" And I'm like, "In New York, no freaking way. No way. Don't do it. Don't do it. Do not change her locks on her." And he's like, "Why?" I'm like, "Oh, she'll drag you to court." I think in the end, they paid her like some obscene amount, like 20 grand to leave. He just gave her $20,000 just to leave peacefully. You ask someone with a peaceful ejection, if it's consensual, right? You give the person a bucket of money and let them leave. And she left. And that was cheaper than having to deal with a wrongful ejection action and litigating in court for 6 years. So when you have a holdover who won't leave, you're basically screwed. There's not much you can do if they're determined. Yes.
I know sometimes like tenants can file like rates of reentry, or like sometimes the landlords will threaten or turn off like their utilities, and the tenants can file for that.
Okay, my uncle asked us, so can I turn off for power? Right, this is in the winter. Can I turn off for heat? I'm like, no, don't do that, because that's a wrongful eviction action, right? If you cut off their electricity or their power or their water, you're actually liable in tort. Now, I don't know if this live-in aid actually had the means to bring these lawsuits. Maybe she just would have left quietly, right? But if you're competent, you can actually extend it, and that sort of makes your hands unclean, so to speak, and makes it harder to evict you quickly when you're so. Just go through the process. But if you're in New York, it's going to take you a while. 1 and 2.
So when the council places that 24-hour notice on the door, is that doesn't turn into a warrant to make them come out?
Well, they usually knock on the door saying you need to evict in 24 hours for like leave in 24 hours. They're not home.
They're at the door and you just, I was asleep. And she did not open the door.
What happens there eventually?
I'm done. But she just ignored the cops.
I mean, what's that phrase? Ignorance of the law is no excuse. If a console is banging on your door, but you're hammering a sign on your door, that's good notice. Instead for like service or process, if you ignore the process server, in this case, banging on your door and nailing to your door is good enough for service.
But if they don't open it?
Well, at some point, the police will have to enter and forcibly remove you, and they do that with or without handcuffs. I mean, that's what we come down to. At some point, if you resist the eviction order, the police will use physical force to restrain you, put you in a car, and drive you out. I don't know if they'll actually arrest you, but they may grab you and you don't. This is going to criminal law, but you don't want to be accused of resisting arrest, right? Because that itself is a crime. So if the cop says, "Please," no, what's it? Refusing a lawful order. You ever hear that one, right? If the cop says, "Please leave your house," and you don't, they can arrest you for refusing a lawful order because they have a court order saying get out, and you didn't get out. Yeah, 1 and 2.
Was summer proceedings until Easter and or summer season over? Is there like something come up?
No.
Option like horizons?
No, I mean, it doesn't. The idea of the summary proceedings and the delays is even if the lease is over, the person stays there until the constable knocks on the door. So until you actually get the final order of eviction, they're going to stay in the unit, and there's no guarantee they pay the rent. or they pay their utilities, or they pay anything else. Yeah, Pierre.
Yeah, so, following up on your comments, so I was actually thinking on correction of justice if the tenant does not comply with the police officer. Is it neutral for the law enforcement to actually proceed criminally?
Probably not. I mean, this person's down their luck. Unless they assault the officer, then you're in trouble, right? You see this sometimes where they're just YouTube people being evicted, and like they start punching at the officer. Okay, then you're probably gonna get charged, right? I you know I'm giving advice to the wrong crowd, but leave peacefully. Don't make it worse on yourself because yes.
Is there any rule for when a landlord can file for an eviction again? Should he lose, like if he files too early the first time after the notice?
Well, that's a good question. I don't know. I mean, I suppose the day you're eligible, if you can file again, I don't think there's a limitation period. Good question. Yes, Arturo.
I think we found it like the.
Oh, you just come right back and file it right away?
I had people that were living in town, you know who they were, so I just guessed their name.
You guess their names, John Doe?
Yes, well, I put all parties inside, but the judge said that, the JP judge said that was too specific, so I asked the judge if I could get their IDs, so I know who they were.
So you brought them into court just to get their
Yeah,
IDs.
they were just spotters who left, like, who did after the tenant had left out, so I got their ID there, and I went to, literally had all these miles.
Yeah, I read an article. This weekend. There's a house in Fairfax, Virginia, which is a very wealthy area of Virginia, and the guy's selling his house. He wanted like $800,000 cash, and he said in the description, "There's a squatter in the basement. It becomes your problem." He's like, "I don't know how this guy got here. I can't get rid of him. You're buying the house as is with this dude in the basement. Your problem." He's like, "I don't want to deal with it. Just give me cash to buy the house." He took like significant cut off the sales price so someone else deals with this with the eviction. And this is not this is a very wealthy neighborhood and some guys in the basement. And he didn't shut the heat or the power or the water. That would be bad. He said, "All right, selling the house, someone else's problem." Yeah.
Right. If there's no living room, then you can say, well, I stopped paying the heat for the water.
I don't have a good answer for you. Yeah, I mean, look, landlords can try and get funky. We'll do some cases next class about what happens when landlords maintain the condition, what we call slumlord, right? They maintain dilapidated conditions. Landlords can play dirty also. But in these sort of well-to-do neighborhoods, I mean, I guess you can shut the wireless off. That would get to them pretty quickly, right? I'm not sure if cutting off the Wi-Fi is a violation of the implied warranty of habitability. I have to look at that one up. I know, right? You change the wireless path. Is that like changing the Wi-Fi, changing the key to the door? You know, you can't connect to. I'm being somewhat facetious, but I don't know if cutting off the wireless is like cutting off the power. Changing your Netflix password. I mean, I don't know what things we can do. All right, one more, then I want to move on. Yeah.
At what point does the squatter become guilty of criminal trespass?
Well, look, it's not going to be prosecuted because in theory, he could say, "I thought I was here legally under the lease," and you would actually need to decide, was he legal under the lease? The more likely scenario is you just kick him out. In other words, if the guy I mentioned in Virginia called the cops saying there's a guy criminally trespassing my basement, they know I'm here under some leasehold, and the cops won't do anything about it. All right, questions? All right, the next case I also love. I love this case. It's just one of my favorite cases in the book. What's it called? Summer vs. Kreidel. All right, who am I up to? I don't remember. Yes, what's your name? Luke. What are the facts in Summer, please?
So the plaintiff, is the landlord, and the defendant is law student.
Yeah, and rule number one: never mess with the law student, right? Because you have a lot of time on your hands and nothing to do. Apparently, this guy's not very busy. All of you guys are busy. If you do this when you're part-time litigating, you just forget about it, right? Anyway, go on, Luke. Go on to the facts of this. I like this case.
So he leases in an apartment. Corrado has bad luck.
Oh yeah, tell us what happened. Poor guy, right?
He planned to get married, fell through.
Yeah. So what was the plan? Just give me the beautiful plan beforehand, right?
Yeah, he had something like an engagement.
Right.
Broken.
What was supposed to happen if he had gotten married? Everything was going to lie into place perfectly, right? Oh, isn't that lovely? This is going back to our case on the Graham case, right? Where the husband's in school and someone else is paying for his tuition. Then he'll divorce her once he graduates, right? That was the other. That was plan B, right? We never got that far because the engagement broke up. Okay, so now what happens, Luke?
Well, he couldn't afford the rent on his own, so he rented the apartment, and then he wrote a letter.
Oh, this poor. It's a sad letter, right? It's very sympathetic. What was he saying in this letter?
I beg your understanding.
Yeah.
Compassion.
Yeah. Yeah. Okay. All right. Very good. Thank you, Luke. So this is a tragic case, right? This guy had it all lined up. He was going to get married, pay for his tuition. They're going to pay for his rent for this swanky apartment in a high rise. I mean, this guy was living large, and he couldn't seal the deal, right? Right before. I'm sorry, that was me. Right? Not really. Right. So right before the wedding, it broke up, and everything fell apart. The in-laws wouldn't cover his tuition. The in-laws wouldn't cover his rent, and he had to live alone. So he writes this very, very, I think, sympathetic letter to the landlord saying, please keep my first month rent, keep my security deposit, let me off this agreement. I can't pay it. I don't have a key, so I can't give you back the key. He probably never even walked into the unit, right? All right. So Dylan, under the common law, was Summer, the landlord, under any obligation to accept the surrender? No. Under the common law rule, could the landlord have just let the property sit there for a year and a half quiet with just nothing happening? He could. So did he respond to the letter? No, he did not. Okay. He did nothing. He actually did more than nothing, right? For Darvish, what happened when another tenant came along who might have been interested in renting out that unit?
He didn't show it because it's already
Right. So let me ask you this question, Darvish. This is actually, I think, a hard question. Could he have rented out Kreidel's unit while Kreidel's lease was still in effect?
No, because I need to double check it.
Well, he'd only collect rent from one at a time. We'll just acknowledge that point. But if Kreidel's lease was from a date to a date, a term of years, right, fixed period, did the landlord even have the present interest to rent it out?
No, President Crystal.
Yeah, the court didn't talk about that, did they? I don't understand with this duty to mitigate business how you can even mitigate a leasehold. It's not his interest to give out, right? Until the interest is formally surrendered, there's only reversion in the landlord. But the court, yeah, Clark.
But if he knows the guys, crowd can't pay and he's paying.
But that's not what a lease is. A lease is for 2 years.
Right, but is it?
I mean, you're right. No, we're being realist, right? We're ignoring that, saying, well, we know he's not coming back, but a lease is a lease under the common law at least. Andres? But can one side unilaterally repudiate? Can you terminate a term of years early? I mean, this goes back to our class last week. Can one side unilaterally terminate a term of years lease? No, that's periodic. But it is a term of years. Can one side terminate? They can't. Daniel, with the hand up somewhere? Right? A term of years cannot be repudiated by one party. Both sides have to consent. So there was a lease. So I don't even get, as a legal matter, how the landlord can sell a unit or rent a unit out that's not his to rent out. I don't see how that even works. But whatever. It's New Jersey. Sorry, I was in Jersey this weekend and I'm home. Still bitter. I love going home to my parents. I love even more coming back here. It's true. I miss Texas. It's just it's so chaotic and busy there. It just drives me crazy. Okay. So we're dealing now with this question of mitigation. The landlord here did not take any steps to mitigate his damages. There was another tenant who came along and said, I want to rent this apartment. He's like, go look at this one, right? Go look at the other one. Now, why do you think, Nick, why do you think the landlord told the prospective tenant, oh, no, don't look at this one, go look at the other one, right? Why do you think he didn't give out Kreidel's apartment? But the unit was empty, right? It was just completely vacant. And there was no guarantee that Kreidel would ever pay up. I mean, he's in law school now. Maybe he gets more money later, but who knows, right? Maybe drops out because he can't pay his tuition. Who knows? Why would this businessman, this landlord, make this decision to simply leave the unit empty when he could have taken a sure rent payment today? What was his calculus? What was his thinking there?
If the guy came back and said that he wanted the apartment, well, then he agreed with it.
No, but he wasn't going to be back, right? He knew. I'm saying, as a business matter, why would you turn down guaranteed rent today for the possibility of maybe getting rent in the future from a lawsuit? Why would you do that?
Then I don't see why he would say no to money right away.
Anyone want to take this question? Oh, here, I'll go to Gabriel and then I'll come back to Chelsea in a minute.
Well, he's pretty much guaranteed the money, and the law doesn't incentivize him to do anything.
So he's going to get his money from person B, and he might get person from money A versus only one potential payout. In other words,
Guaranteed money from.
he's
person-
guaranteed the rent from the current tenant who wants to come in.
And the
He
law-
might also get it from the future.
Yes, but the law encourages him just to sit there and just.
Yeah, I think that's right. So, I mean, this is not a completely irrational decision. It's kind of weird, but he's saying, look, let me go send this tenant to this other unit. I'm guaranteed that rent, and maybe when this guy graduates from law school, he'll make lots of money. You know, your lawyer's making a lot of money. No, you won't. No, yes, you will. Right? No, law firm salaries are distributed. Right? It's on a curve. No, they're not. I mean, this is a true point. Not everyone makes big law money when they graduate. That's just. I hope you all know that. I got deceived when I was applying to law school. They gave me these statistics like average starting salary. No, it was median was like 160. I'm like, oh wow, that's great. But if you actually look, it's a lot of people bunched there, and then everyone else kind of drops off sharply. So the law schools actually had litigation over misleading statistics. Now it's all well known, but law schools were very. When I went, I had the material. I threw them out a couple of years ago. Like what they totally promised us was just wrong. Anyway, assuming he makes a lot of money as a lawyer, go after him for his unpaid rent for a couple of years. So he wants to double dip, right? Get the money here and get paid later. I think that's what's going on. All right, Nick, I know your hand got up. Yeah.
Right there, because it's not the way for a lawyer.
Well, but look, he's gonna get the money right there no matter what he does, right? He'll get the rent from unit A or unit B. This at least preserves the option that he also gets the rent from Kreidel's apartment. Darvish?
Also, I was gonna say, because he's the landlord, so to have, the first, Kreidel's original apartment would still be under occupancy.
Correct.
And so to have two under occupancy, if you wanted to sell or something, it's really.
Yeah, lucrative. Yeah. I mean, look, he was basically hedging his bets at some point in the future he might collect from Kreidel. That's what was going on, right? He thought maybe Kreidel graduates law school. I don't know if the statute of limitations, someone asked when you have to file. I don't know if the statute of limitations is in New Jersey, maybe it's 2 or 3 years. So you can basically wait till the kid graduates and sue him right away for the unpaid rent, I think at least. I don't know. All right, so he lets the unit stay open, and then eventually, about a year and a half later, he puts out a tenant, says to fill the unit. Okay. Finally, he brings a lawsuit, and he sues for unpaid rent. Chelsea, what happens here? What does a trial court do? They apply the common law rule. This is this amazing common law rule, right? What's the common law rule? Correct. The landlord has no duty to mitigate. And Chelsea, we're in New Jersey. What happens to the common law rule? What always happens in New Jersey? They reverse. Thank you, Chelsea. Right. Here is conveniently not here, but I'll get to her eventually. It's your computer. Oh, I feel like a jerk. Okay. I had this one semester a couple of years ago with this one student. She would always go to the bathroom when her term was coming up. It was without fail. I mean, it was every week. So one time, the second she walked in, I called her the door. She didn't even sit down. I called her. And anyway, it was very frustrating. It was obvious she was going to the bathroom to avoid my calls. I don't know. Do these hall passes, do professors have that limit on bathrooms? I've never actually limited bathroom use. I think it's kind of weird and creepy. I don't want to know what you have to do. I mean, students, I don't want to criticize. Students send me pictures of their thermometers to say they have a fever. I don't need to see your thermometer. I believe you. If you tell me you have a fever, I believe you. I don't need to see what your thermometer is. I don't. Does the school require thermometer selfies? Is that a thing? I don't know. I'm not criticizing, but I swear, I once had this was many years ago. She's long since graduated. A student emailed me and said she had IBS. I was like, I don't need to see this. I could not unsee it the rest of the semester. Like, I don't care. Like, I don't need to know. Anyway, so I don't know if I got this tangent. Oh, poor Kira. Okay, so I called him right. Dakota, I was only calling you, right? So why does the why does the New Jersey Supreme Court abandon the common law rule?
That's what it says. They use by saying that they have a landlord.
Right. But they acquire a duty to mitigate. But why do they abandon the common law rule? What rationales are given? Unfair. Why is it unfair? Back to students. Remember this one, yeah. Why is it unfair? Oh, I can't see him.
Because of the,
I'm sorry.
well, I guess it was fairness.
Yeah. Okay. So what does this mean? Fairness and equity. What does that actually mean?
I believe that the tenant is entitled to that lease from the lease and the landlord.
But isn't a term of years you can't terminate early? Why is this so unfair? Don't you know what you're getting yourself into when you sign a lease?
Well, but I guess the landlord knows if they're not gonna pay rent, they shouldn't just wait and try to collect all of that.
Right. And so the thinking here is the landlord's in a position to reduce the total number of damages. He should take that position. Okay. So they abandon the common law rule and they adopt this new standard that the landlord must comply with. Kevin, what is this new standard that they adopt?
That the landlord should make an effort to occupy dignity.
Correct. Okay, very good. The court follows what you might call a reasonableness standard. Everything's reasonable in New Jersey, right? Everything's reasonable. And these word reasonable. The landlord must take reason to relet the apartment. Even if the landlord has other apartments that are empty, he must treat the breaching tenant's unit as vacant stock. Okay. Now, who has the burden, Arturo, in one of these eviction cases? Is the landlord or the tenant? Who has the burden? Arturo, let me ask you a question. You did contracts now for a year. Usually in a breach, who has the burden? The breaching party, the non-breaching party? I'm sorry? So if I breach a contract and I get sued, who has what does the breaching party have to show?
The breaching party said that they didn't breach.
Yeah. Or there's some excuse of why they didn't perform, right? Does the tenant have any duty here? If there's a claim of failure to mitigate, does the tenant have any duty?
I want to say yes, but they wouldn't have access to
Good.
that information.
Who has the burden? The landlord. Under the rule the Jersey court crafted, it's the landlord that has the burden. And the landlord must show that he used reasonable, there's that word again. The landlord must show he used reasonable diligence to relet the apartment. Right? So again, the tenant breached, but the landlord must show he used reasonable efforts to relet. If he fails to show that, then he's on the hook and he can't sue for damages, or his damages are reduced. If the landlord cannot show he's reasonable diligence, then the damages will probably be reduced. Not to zero, but at least to reduce somewhat. There are going to be some damage that are due, however much time elapsed, right? The damages will not be zero. Then the court identified several factors that trial court should consider. Factors, we all love factors, right? Did the landlord offer to show the apartment to prospective tenants? Did he use a listing agency? Did he advertise in newspapers? And even if the landlord took all these steps, that might not be enough. The court says there's no standard formula or favorite. Each case must be judged upon its own facts. So, right, shrug emoticon, I don't know, right? It's giving the lower courts no guidance. It's giving New Jersey landlords very little guidance. And it's giving New Jersey tenants a lot of inspiration to stay over or not pay the rent, right? I mean, this is a rule that again makes it very hard to leave a unit empty, right? So if you're a landlord in New Jersey after this case, you're probably not keeping your apartment empty. right? You're going to try and rent as quickly as possible. Otherwise, you're on the hook for damages. You'll collect no rent at all. Yes. No. Now most states have adopted a duty to mitigate. I'll get to that point in a couple of minutes.
If the tenant has 3 empty units, and the 4th one is the one that just, is not being paid. Are they obligated to fill that first as opposed to the other?
Look, if I am a lawyer in New Jersey, which thankfully I'm not, I would suggest, I was actually just said, I would suggest you rent that one out first, assuming that they're all comparable. Like, maybe it's a 1-bedroom apartment, a 4-bedroom apartment. If you have 4 apartments that are roughly the same, then you rent out the one that's the that's the vacant apartment first, because that way you can't be accused of failing to use diligence. Right? I'm not sure how the court even found out about this other tenant who was interested but left. I'm guessing there was discovery or something. I'm not entirely certain.
Just in that scenario, let's say it's 4 probably similar ones, but the tenant absolutely refuses to take over the one that was vacated.
Yeah. Yeah. Maybe the tenant's like,
waiver, or
I think reasonableness is a reasonable standard. So if you tried and the tenant says, I don't want that one because there's a view of the street, I want the view of the window of the park, right? Then that might cut against it. But in this case, someone said, I want that apartment. Like, it's not for sale. Won't even show it to you. Right? Not all units are the same, right? Different parts of a building might have different benefits. You're facing the street, you're facing the garage, you're facing a parking lot, facing construction. I recently stayed at a hotel and my window's overlooking a construction site. So like at 6 in the morning, there was construction. The other side of the hotel, there was no problem because it's facing the street. So, where you are, it doesn't matter. All right. So in this case, there was a classic example of unfairness. The landlord waited 15 months before relaying the apartment and allowed $4,000 of damages to accrue. Another tenant was ready and able to take the apartment, and he turned him away. Summer could have avoided the damages, but he didn't. Therefore, Kreidel was relieved of his duty to continue paying rent. Starting at what point? Not exactly sure. The court sort of sent that back. But of the $6,000, probably at least $4,000 were not going to be due. I think you would probably start counting at the point where the other person could have moved in, and that's when you cut it off. So in the end, he made this gamble. He's like, look, I can get this rent and the other one later. He lost. Not only that, he paid legal fees all the way up to the state Supreme Court, which was probably a lot more than $6,000. This might have been something of a test case. I mean, they usually are, where the realtors of the state kind of pulled together money for this litigation because they want to establish a precedent to ensure you could do what they did, and they lost. Kevin? Yeah. Yeah, that's right. Yeah, that's right. Yeah, so this is probably a test case of some sort. The lawyer though, Kreidel, the law student, actually did this one on his own, right? I love this fact of the case. So it's in the book afterwards that in the litigation, Kreidel had cited some case from Oregon, and he said, and the other lawyer said, Oregon's known for fishing salmon and for logging, cutting on trees. So after the case came out, he took some salmon and some wood, and he wrapped in the court's opinion, mailed it to the lawyer. And he said, "All right, touche." I wouldn't recommend you do this. It's kind of I'm guilty of this, but gloating in victory. Be gracious when you win. It's hard to not just yay, showboat. It's true. I mean, people celebrate, but be gracious. And I'm guilty of this also. I get happy when I win. But anyway.
I kind of have a question on what you're saying right now. So I know that the trial court found that he basically accepted to sign the lease when he was signing about it, and then other court reverses. So I guess the Supreme Court, when their decision to reverse the other courts, the trial court's decision still goes, or did he have to pay somewhat of the damages?
Right. This is the question. I don't know exactly how much you have to pay. If I had to guess, they send back to the trial court to figure out the exact amount that was owed, right? The duty to mitigate doesn't reduce damages to zero, but it probably reduces from maybe 6,000 to 4,000, 2,000. There's some amount. I don't know what that amount is. So a hand somewhere else. Was no hand? All right. So, yes, Trey.
On the burden of proof part, is it the majority that have the tenant or the landlord
I don't know. I don't know if in the majority of states the burden's on the landlord, but I'll say this. In most cases, it's not going to be clear whether it was a reasonable duty to let out to others, right? Other than checking newspaper advertisements, etc. How is the tenant possibly supposed to know if people came by to look? So this might be a rare case where it makes sense to put the duty on the landlord, but I'm not sure if all states does it. But there is a duty to mitigate. I just don't know who has the burden. And according to my notes, I think about 42 states have a duty to mitigate, including Texas. This is only for residential. Fewer states have it for commercial. Okay. Yes, Sophia.
So the only remedy that can be undertaken without the court system is under common law, retaking if there's the two conditions of.
Correct. Right. But virtually no jurisdiction. I think it's either Louisiana or Mississippi. I can't remember which one allows self-help. So it's been very rare they can actually use something outside the judicial process.
We could still cite it though,
Sure.
in like.
If you're in a common law jurisdiction, a magical theoretical common law jurisdiction called Mississippi, you could. I can't remember, is it Louisiana or Mississippi? I'm blanking. I did this research last year and I just can't remember. Arturo. I'm not sure. I'm going to say no. Because I think that's even worse. Like if you have businessmen fighting each other, right? Because at least I think the answer is probably no also, but I'm not positive. Don't do self-help. I know it sounds cool. Oh, he's not here. Don't shoot anyone, right? Don't shoot anyone. Don't change your locks. All right, it's a good idea just to go to the courts and wait a few weeks till you'll get your property back. Unless you're in New York where it takes like 6 years. All right. Other questions? All right. That's all I have. Have a wonderful day, and I'll see you soon. Yes, sir.
Quick question. So in